on this day, personally, I would have been delighted if all 7 of us could have spoken in the same voice. Today's split verdict highlights the diversity in perspectives and interpretations of judges. Since judicial opinions vary based on individual differences, I find myself in the trio of minority. And inter se the minority, I am again in the minority. We have all been discussing about minority, and today, no one other than me characterizes minority best. I will not read the entire opinion. I'll read only paragraph 1 and the last paragraph. And in between, I will highlight what has been held by me. I have started by saying, there is a saying, the past refuses to lie buried. Possibly no other case would demonstrate the validity of this statement more poignantly. Having perused the records, I found that the order of reference of the three-judge bench in 2019 had its roots in the order of 1981, Anjuman. So I have referred to Anjuman as the reference order. I have referred to Aligarh Muslim University as the re-reference order. Anjuman order, a bench of 2 judges directly referred the issue to a 7-judge bench. The majority opinion is that such a course of action is permissible and within the parameters of Dawoodi Bohra. I have referred to several other decisions which have laid down the procedure when a 2-judge bench, even in case of doubt, cannot refer the matter other than to a 3-judge bench. A dangerous precedent is being set. A 2-judge bench tomorrow may say, I doubt the basic structure. I refer it to a 15-judge bench. And this is what exactly would happen if we accept the majority opinion as the final opinion. Of course, it's the final opinion. Can it be done? Are we not in the process overruling Lala Shri Bhagwan, Chief Justice Gajendra Gadkar's judgment of 1967, Pradeep Chandra Parija, Hansoli Devi, Dawoodi Bohra, and again in recent times, campaign for judicial accountability? I have held the reference order to be totally non-est. I have also examined the 3-judge bench order of 2019. I need not elaborate here for the detailed reasons. I have also held that order to be non-est. The references were therefore unnecessary. These are all technical points. I have thereafter gone into merits and said the observation in Anjuman that there is no clear decision on the point as to whether a minority institution can be established with the aid of even non-minorities. There is no clear decision. Very Mother Provincial directly answered that in 1970, which the bench in 1981 was not referred to by the very set of very learned senior counsel who appeared before the bench. This has also not been noticed in the 3-judge bench order. So far as the 3-judge bench order on merits, let me say this. The 3-judge bench noticed that TMFI did not consider 3A, but the 3-judge bench did not notice that TMFI was followed by Islamic Academy, 5-judge, and PA Inamdar, 7-judge. These 2 constitution benches were constituted for the purpose of ironing out the creases flowing from TMFI. They did not consider it necessary to lay down what the indicia is. Even the regular bench to which the matter was referred did not answer it. So today, by laying down indicia, we are discrediting the judges who have adorned the bench of this court right from 1950. It was an implied indicia that they had applied. I have said if it is necessary to lay down and express indicia, it has to be prospective, not retrospective. Thereafter, I have looked into the enactment of 1920. I have traced the history, and ultimately, paragraph 150, I have concluded that in terms of clause 5 of Article 145, it is my firm opinion that not only do the references do not require an answer, it is also declared that ANU is not a minority educational institution and that the appeal seeking minority status for it should fail. Before parting, I have expressed my sincere appreciation for the members of the bar who have addressed this bench. Listening to their erudite arguments was indeed enriching. I have expressed gratefulness to my research associates who worked tirelessly and burned the midnight oil to help me win the race against time. The scholarly contributions in books and treatises which were consulted, as well as the artificial intelligence systems now available, which have opened up a whole new world, did provide me with valuable guidance and inputs. Lastly, the assistance and cooperation received from this court's library also significantly enhanced my work and made my opinion richer. I regret my inability to acknowledge the contributors individually. That is my opinion.